The guest is Anthony Laronde, and he will discuss freedom of expression. Tune in this Thursday.
Good evening. Welcome to yet another program. And tonight we're hoping to have a very exciting one for you. We have the most distinguished Gloria Augustus, a magistrate and a great Dominican who has a passion for what she does. And tonight we're going to be looking at two pieces of very important laws here tonight, namely the Maintenance of Children Act and the Maintenance Act. You may recall in the recent past, the government enacted a suite of family laws. The intention, therefore, was to upgrade and to redefine the manner in which the magistrate court deals with the whole issue of child maintenance or the maintenance of children, and of course also ensure that the rights of people who cohabit could have been preserved and further protected, and also ensure that every member within the family can be protected against the ills of domestic violence. But tonight specifically, we will be speaking to two very significant pieces of legislation insofar as the suite of family acts are concerned. And tonight, we're not going to waste too much time. We're going to get straight into the action here tonight and introduce our most distinguished guest here tonight, Ms. Gloria Augustus, an attorney by profession, but she has sat on the bench and still continues to serve this great country. And we are so delighted here tonight to have her to share with us, and of course those of you listening in Dominica, overseas, and wherever you may be listening. I'm hoping that, of course, this tonight's program can be of tremendous benefit to you, especially those of you who are involved in relationships and those of you with children, and you need to know your rights and to ensure that you take care of your children, and those of you who actually have the obligation to take care of your parents and your grandparents. And tonight she'll actually share with you some of the things that you need to know. So good evening to you, Miss Gloria Augustus.
Good evening, good night.
How are you doing?
I am okay.
Yeah. Okay. Tell us something about yourself and about yourself. I know you for a long time, but tell us about who you actually are.
Okay, I'll keep it legal. My name is Gloria Septra Augustus. I have been an attorney from 2001. I became a magistrate from 2004, and I took a break in 2017 to 2019 when I worked at the OECS Commission as a technical specialist in juvenile justice, and I returned to Dominica in 2020 and continued as a magistrate. When I initially started as a magistrate, I did mainly family matters that has to do with custody, maintenance, juvenile matters, and domestic violence, and some traffic and other matters. And but since I came back after 2020, I started doing a lot more criminal and civil matters than I used to before I left.
Mm-hmm. Okay, great. I know, were you involved in acting before? To me, you were involved in...
Yes, I have been acting since I was at school. And I love drama. I have been in drama. Also, I'm part of a drama group called La Cudeza de la Dominique. I was part of the People's Action Theatre. And I have worked in drama as an actress, as a producer. And also, we had a project with my group where we had a joint secondary school drama group, and where we had a very active drama group for a number of years with young people. I also took part in a television series on domestic violence as Marianne. That's where a lot of people probably still remember me. So yes, drama is part of my DNA. And that's why I want to see the Arawak House of Culture back on track.
Okay, But did you serve also externally, regionally? You served
Yes,
for
I
a
did.
while.
I worked at the OECS Commission as a technical specialist in juvenile justice.
So you're quite suited here tonight to actually try to help the public to better appreciate and to understand their rights and their responsibilities, also an obligation on those two of the pieces of legislations we'll be talking here tonight about here tonight. So let us start and let's go straight into the action there, and let's start first by addressing the Maintenance of Children Act now, and we may want to start to first of all define for the purpose of the act who is a child.
Just before, I would just want to go back a little and say that prior to May 2023, we had one Maintenance Act.
Yes.
And since May 2023, we now have two, which is the Maintenance of Children and and another just Maintenance Act, which sort of separated what used to be in the one act.
And I think the reason for that was very deliberate. And as I said just now in my actual introduction, was to more or less redefine the manner in which the magistrate court or the court deals with matters concerning child maintenance, or Maintenance of Children Act, as it is called in law. And so yes, and then we have the Maintenance Act that speaks to the whole issue about people who are cohabiting, and of course the obligation to take care of the grandparents and the parents. We'll get to that maybe after we look at the Maintenance of Children Act. Yes, thank you very
Okay,
much.
so the Maintenance of Children Act is it's part of a harmonized law in the region, and there was a need for us to revise and review our law so as to bring it in line with the rights of the child, the Convention on the Rights of the Child, and a lot of it, if you look at it, it really has some aspects of the clauses of the and the whole spirit and intent of that convention, and so much so that is why now a child in this law is a person under the age of 18. Because in the convention also, a child is under the age of 18. But it even goes further in this law and says a child is a person 18 years or older who is unable to reasonably provide for his or her daily requirements because that person has a serious illness or a physical or mental disability. In the old law, we didn't actually say that. But what happened was that if there was a child with a physical or mental disability, the maintenance didn't stop at 15 or 18 in the old law. It went on because in that condition, that person would be considered almost like a child, 46, but still a child because of the physical or mental disability. But whereas in this law, it actually spells it out. And it says that even if you are 18, 26, 25, 40, but you have a serious or mental disability or serious illness, then for the purposes of the act and maintenance, you are still considered a child.
No, that is very important, and I would wish, if you don't mind, for you to repeat that. Because and that is why those programs are so important. So because a number of times, so we see a number of people who are vulnerable, who are challenged mentally, and they're left on the wayside. And somehow the parents of that person who was vulnerable, or the family members, believe it's the obligation and responsibility of somebody else or the state. So I think it's important for you just to just go over what you have just said.
But based on my experience, we had people in that category. So notwithstanding that someone is over the age of 18, if they have a serious illness or a physical or mental disability that doesn't allow them to take care or reasonably provide for themselves, then they can be maintained under the Maintenance Act, and they're considered a child under the meaning of the Maintenance Act. What I'd like to say also is that in every law, in every act, there's a section called an interpretation section, and there are words there, and they're given their special meaning under the law. So under this law, a child is a person under the age of 18. The second one, a person who is 18 and older, but if they are unable to reasonably provide for themselves because of that physical or mental disability, or serious illness, then they're considered a child. And there's this novel one, which some people know about it, some people, I think it will continue to be a matter of debate, and which is what we're using now. It says a person 18 years or older, but under the age of 25 years, who is receiving instruction at an educational establishment or undergoing training for a trade, profession, or vocation, whether or not he is also or will also be in gainful employment. To put it simply, persons who came to the court prior to May 2023 for maintenance would be told that maintenance is up to the age of 15, but if the child continues to go to school, up to the age of 18. Under this law, it goes way beyond 18. So if that child or that person is 18 years or older, but still going to college or university, then there is an obligation to maintain, and it is covered under this law. And some people are not too thrilled about the age of 25 and whether or not he will also be in gainful employment. So that young person could be working and going to school or going to university or working part-time or something, and there's still an obligation to maintain. But the good thing about the law is that there are guidelines, and everything would be on a case-by-case basis, and there are certain things that you would look for in determining whether this is a situation where you have to make that order, or the extent or the level of the order.
Great. Okay, I think you have been very comprehensive there in actually defining, as per the requirements of the law, who is a child. Let us go to another important aspect of the discussion here tonight. And something, of course, that sometimes becomes a very vexing issue before you on your bench, as I've been saying over the years. The obligation to maintain a child. Who is obligated to take care and care for a child under Section 4?
Okay. But prior to that, whatever is done in terms of the obligation, there's one thing that people do not, well, sometimes it's difficult to wrap it around the head, that whenever we're looking at maintenance of a child or obligation to maintain a child, we have to look at the welfare and best interests of that child. And that includes the child right to care, the child right to support, the child right to development, the right to be, all these rights have to be respected. And this is something that people have to keep in mind. Because many people think that, okay, there's an obligation to maintain, but maintain for what? It's not just about maintaining for food. So who has the obligation to maintain? So under Section 4, there is also a novel area. But I will first of all read the one that we are accustomed to. Mm-hmm. It says, each parent of a child has the obligation to provide reasonably for the child's maintenance, whether or not that child is in the parent's custody. So the child doesn't have to be with you physically. Once it's your child, then you have an obligation to maintain. But maybe I should go back to, in terms of child, there's some other clarification or qualifications. For instance, in that law, they speak to biological father and biological mother. In the law we had before, there was no mention of biological in the Maintenance Act that we used prior to May 2023. No mention of biological. It was said putative. Mm-hmm. Putative father. More likely than not, you bingo as the father. We would have to ask questions, and then the magistrate, based on what was said, would decide whether more likely than not there's a probability that you are the father.
Let me give you
putative father.
Let me give you a joke. There was a lay magistrate when I was a young police officer in St. Joseph, and I don't know what to call his name. Once he asked a question in Patois, Opasela?
Oui.
Okay, thank you. Right, okay, fine.
So we have to, that's why I said sometimes we go the long way, where we have to ask you when you pass there, how you pass there, and and then after that there is an order, a direction that you are the putative father. But this one actually speaks to biological father, mm-hmm. And even that has categories. So you can be biologically the father of the child, or you could be adjudged to be the father of the child. That is where the whole putative aspect comes back. Or you could be presumed to be the father of the child. And that presumption comes out particularly in terms of artificial conception. So if you are married to somebody, there's another law we have called the Status of Children Act. So under that, it deals with that. So if you're married and your wife has a child, it's assumed, presumed that you are the father of that child. If you all have gone into artificial conception by consent, it's presumed that you are the father of that child, even if the sperm doesn't belong to you, that type of thing. So in this case, it's forward thinking, and it takes that into account. So you can be biologically the father, DNA 99.999. You could be adjudged to be the father based on certain situations, and also you could be presumed to be the father under artificial conception procedures. So whichever way you are the father or the mother, because the mother too could be as a result of artificial conception, or you could have given birth to the child, both of you have the obligation to maintain the child. And there's another child that you have the obligation to maintain also, which is called the child of the family. So notwithstanding the child might not be biological or artificial conception, if that child is a child of one or both of you all, that child lives with the family, that child is considered to be a child of the family. The only way the child will not be a child of the family is if that child is placed with you through the welfare division or some authority or organization. But anyhow, you treat a child, for instance, your cousin has a child, the child has been living with you all for umpteen years, child of the family, you have an obligation to maintain. Right? So there are several examples where the child might not be biological, it might not be through artificial conception, but if that child was raised in the family from whatever age or for whatever period of time, then that child can be considered the child of the family. The magistrate would have to look at all the other situations, what happened, how was the child treated, was the child accepted by both, and that type of thing. What was the home that child knew from the time the child was whatever age. So child of the family has to be maintained. Child has to be maintained by both people who have the obligation to maintain that child. Also, if a person has custody of a child or guardianship, you can get guardianship through legal means where you have the responsibility to take care of that child. Then also you have an obligation to maintain that child. Also, a person who stands, as the law says, in loco parentis, meaning that you have taken on the responsibilities of a parent, of that child as a parent. So there are some people that have just taken on other people's children and they are operating like it's their child, they're taking on the responsibilities and so on. That person also, based on the length of time and other situations, can be made to pay maintenance for that child. Wow. And then there's a novel one where if a child is over 14, that child on the child's own behalf or through another person can make a maintenance or can apply for maintenance. So sometimes there are some parents who say, me, I don't take any man to court. But then the child is saying, boy, look, my father or my mother, has that way of life and I am going, or I think that they should maintain me. That child can, on their own behalf or through some agency, make an application for maintenance to maintain them.
So we're now talking about the types of orders right now.
No, we're talking about who has an obligation to maintain.
All right, fine.
Right? So each parent has an obligation to maintain, but also those who are guardians have an obligation to maintain. Those who take on the responsibility in local parentage have an obligation to maintain. And the child who is 14 years can apply and say, I need maintenance. So under that, we see that it sort of expands. Before, what we had was mainly mainly just the parents having an obligation to maintain, but now we have even the guardian, the one who is in loco parentis, and we also have this new thing where a 14-year-old can, through their own behalf or through someone, come before the court and seek maintenance from one of their parents or both of their parents.
Okay. If we may want to briefly, although you have spoken about who can apply for an order, and I guess you're making reference to maybe Section 5. So if you may want to look at the types of orders available under the Act, just to give people just some clarity.
All right. Well, once you come under the Act, you come in for maintenance.
Right.
So you can get the maintenance order, but then within the maintenance order, we also have what we call an interim order, or also we can make a lump sum order. So, for instance, the maintenance order would be the regular thing until it is removed or varied or discharged, and the interim order would be an order made for the time being. So, for instance, if some persons come to the court and then there is a question of, oh, I want to do a test first, but then your intention is to do the test in 3, 4, 5 months' time. In the meantime, an interim order can be made. If there are probably two different matters happening that involves the child, for instance, a custody matter, and it is taking some time, it's protracted, in the meantime, an order can be made for maintenance. Also, even under domestic violence, if there's a question where there's a problem and then there's a child who needs to be maintained before the matter is resolved, an interim order can be made. So an interim order is an order for the time being. And also we have what's called a lump sum order. So for instance, sometimes someone may come to court and service a lot of times is difficult, and somebody may be walking up and down the court for 6 months or maybe even longer than that until the other party appears. So their matter has been filed 4, 5, 6 months, and when the other party appears, that party may say, well, I haven't maintained for how much time, for whatever reason. And in addition to the normal maintenance order, which would start on a particular date, you could also do a lump sum order for back payments. And you could also do a lump sum order for back payments even for hospital. So for instance, if it's a very young child and you would like to claim for, what they call it, layette and hospital and so on, that can happen. So, but usually these amounts are estimated based on evidence given from both people, and you give them a time to pay. So once that lump sum is paid, that's it. But it also has a penal clause like the normal maintenance order. So the regular thing would be the maintenance order. The interim order would be the order in the meantime while you wait for something else to happen. And you can also have a lump sum order to cover back payments, either for maintenance or for some particular stage in the child's life.
Okay, great. Okay, I think you have already dealt with as to some of the issues and conditions you must consider.
Oh, I forgot another one.
Yes.
An attachment order.
Order, yeah.
Yeah.
But,
this one is new. This is where you could say, okay, it will be paid for through my employer. Just like some people take that, for instance, if they have a loan, they might ask for the employer to pay it, to deduct the money from their salary. So that can happen. So with an attachment order, which wasn't there before, we did it, but it would be by consent and with a special document and so on. But this law actually allows for that. So if an attachment order, you would bring in a particular form or make a request to your employer, and if this is happening, the employer has to pay it regularly. And if you are no longer in the employer's employment, the employer has to inform the court about that, and also you too, because what happens is that if the amount is being deducted and not paid, that employer can be brought to court to pay arrears. I've seen it happen in action in Antigua, where an employer was deducting the money but not paying it, and the employer was brought to court to answer as to why it's not being paid. So the attachment order is for your employer to be paying the money, and if it's being deducted, just like Social Security, some people deduct Social Security and don't pay it. So if it's being deducted, not paid, or anytime there are arrears, then that employer is called up as to why this is not being paid. And if it's no longer in your employment, you have to take out yourself fast and let the court know that.
No, it's interesting that you're making reference to the fact that if you're no longer gainfully employed, you have to inform the court, because I'm just reading some.
No, where there's an attachment order, I'm talking about.
Yeah. But
because even that, everybody will say they're unemployed.
Yeah, somebody is saying that if you don't have money, you can't take care of the child. But before you issue an order, there are certain conditions that you consider. Isn't that so?
Yes, but when it has to pay money, people don't like to pay money.
I know.
And particularly where the people have issues within themselves. Some people are unable to see that it's about the child.
Precisely.
And they see it's about the other party. So sometimes, you wonder, well, if you are being maintained, if you are fed, you won. Much as for the person, with either 1, 2, or 3, there is need to give some support. Because as we know, it's not cheap for anybody, not for 1, much as for 2, 3, and 4. So if we were to say, well, if you're not working, well, I think our job would be very easy, because everybody will just say, I'm not working. Some people are not working formally, but they're working informally, or they're working on their own. So it's not a matter of you just come and say, I'm not working. Because you'll be questioned. There are other things, there are guidelines there, because there is a child who has to be maintained. And remember, we're looking at the welfare and the best interest of the child. And that includes a right to care, a right to support, a right to development, education, and so on. And therefore, there has to be a way for that to happen. And another thing I think we need to put early on is that prior to this law, the maximum was $75 per week. The way that we calculate the week is from a Friday to a Friday. And generally there are 4 Fridays in a month if you look at the calendar, but 1 or 2 months in the year there are 5 Fridays. So in the law prior to that, for maintenance that we did for maintenance of children, the most that the court could ask somebody to pay at that time would be $300 when the month has 4 Fridays, and $375 when the month had 5 Fridays. That is no longer the case in terms of maximum. Now there's no maximum in this new law.
But
there is a minimum.
Right.
So the maximum before has now become the minimum. So this is where we start. And in the old law, I think that also people had this, once you said maximum, it's like, I'm not going there. So there was some aversion to go up to that point. Now it is the minimum. You have to start there.
Yeah. And so in terms of the actual application before the court, how based on your experience, does it give the law itself a greater degree of utility, and insofar as ensuring that a child is properly maintained, or do you believe?
No, well, you have to start there. The thing is, the utility is based on how you pay. Because yes, you start there, but then if you never pay, then you have the whole question of arrears and coming back for arrears and that type of thing. And there are some people who recognize that and who say, okay, I will, or I'll pay more. And there are some people who talk about how it's hard for them, and but everything has to be done based on the information. You look at the financial needs of the child, the standard of living of the child, you look at the income, the earning capacity, if there's any property, maybe that or resources of that child, of the parents, if there's any physical or mental disability, because once there's physical or mental disability, usually that goes with a lot of cost. Also, the manner in which the child was educated or has been trained, the standard of living enjoyed by the family, particularly if they were together and they're now separated and they're asking for maintenance. We look at what the child enjoyed. It's almost like you don't want to, the law would not want to demote the child. Also, that law allows for any non-monetary contributions made towards the care of the child. So there are some people who pay, like they have insurance for the child, or they pay certain things, or they or there are things that they do or give. So we look at all that. We also look at the income, the earning capacity, property, and other financial resources of each parent. But for some people, that is a top secret. So usually you have to try to, ask, or you may know, find ways to get that information. And sometimes both parties agree to the amount. You have a difficulty when both parties don't agree. So if the person say, okay, I'll pay the 75 or I'll pay 100, everybody cool. But sometimes when one party says, well, I think he or she can pay 150, or he or she can pay 80 or 90, and the other party says no way, that's when you have the problems. And not I would say problems, but then sometimes, it takes a while to get to an agreed amount.
Now, if we want to look at some of the pressing issue there, or issues, but in particular, a particular issue, an order is made and then payments are not made. This sometimes becomes a very regular phenomenon, whereby the court makes an order for the maintenance of a child, and then the payments are not made in a timely fashion. How do you deal with that?
Well, under the old law, the parent would have to take the matter back to court. This new law allows for an additional way, but it is not working quite as yet, because we have what is called a collections officer under this law. And the collections officer is really supposed to be almost like monitoring what's happening in terms of payments, non-payments, and one of the ways in which the matter can come back to court is through the collections officer having to send out a summons to the person in terms of arrears. But one of the things with this new law I find is that it's tighter than the old one. In the old one, if you were 6 weeks in arrears, that is when you could come back. Or if the other party was 6 weeks in arrears, that is when you could come back to the court. This one talks about 14 days.
Yeah.
I myself would recommend that this be moved up a little, because the 14 days, 6 weeks cause problems. So you can imagine what 14 days is causing. So 14 days in arrears.
So I think about the intention, though, if we're talking about redefining and upgrading, and fundamentally the welfare of the child is paramount. Now, so if you're saying there before the period of time that you had to wait,
yes,
was very, very long.
6 weeks.
6 weeks, of course, is a long time. If you stay without food for 6 hours, for us for 6 weeks, to have a child who cannot care for his or herself. So and maybe a law itself, the intention is appreciated when it's actually been applied. So if you as a practitioner say in 14 days, of course I heard that before, can be very tight.
I would probably even just say 4 rather than 14 days. At this 4 brings it to like a month,
Yeah.
Because some people, they operate on month end, if it's not month end, if it's not fortnight, that type of thing.
Yes.
But the 14 is very, very tight. But the other thing about it is people need, if persons paid regularly, that wouldn't happen. But some people, they take their time, they sleep on it, and then it goes up. And then when they come, then it's a problem. So what I think what that wants, the whole intention is that it would not get to the point where it's like in thousands. So it's like you'll be called up so quickly that you realize, hey, you have to keep moving, you have to keep paying. Otherwise, whereas with the 6 weeks, and when the other party had to bring the matter, sometimes the people would not want to come to court for various reasons. Some of them, when they come to court, they have to get special people for their job, because when they come and they have to wait, it's like a whole day off. And then some employers don't want to pay, some employers are not too pleased with all those days off and so on. So some people really do not like, I don't know, some people just don't like to come to court. And having to come to court, sometimes according to where they're coming from, then you have court plus your bus fare, and then if you wait for a little while, get something to eat in town. So it's, some people would wait for a while. Some people would even wait for it to get to a point where maybe they can get enough to buy something so that they don't have to use it. So I remember once somebody did not pick up her money. I was asking why. He said, oh, well, I need glasses for the child, so I'm waiting till it gets to that point, so I'll just come and take it to buy the glasses. So it's the question of arrears. I think parties who are paying maintenance need to think about the child, think about the welfare of the child, and try and put the money in as regular as possible, so that they don't have to keep coming back to the court. And what the magistrates get is, sometimes you get to know these parties so well that it's a replay. You hear the same thing over and over again. And, in the middle, you have this child who is suffering, because whenever the parents are not, how should I say it? Whenever the parents are fussing over a particular issue, then they exhibit behaviors that influence or affect the children.
Sure. No, it's now 4 minutes after 9 o'clock. We have to go into the next topic here tonight. But before we have
no, I want to mention another area.
Areas that we have
another
to touch.
new area.
Yes.
For arrears.
Arrears under Section 23.
Before, for arrears, and people have gone to the prison for arrears. But in this new law, there's something called intermittent custody, where they can be sent to prison, but sent to prison on license, where they will spend a certain amount of time in the prison, be out for a certain amount of time to go to work, but they'll be on license. But we'll talk about that a little later, when we haven't really been using that, but this is there, because a lot of people they would argue, well, if I go to prison, then where the money coming from? How am I working for the child? That type of thing. So based on that, the law has what you call intermittent.
Yeah, which I think is very progressive.
Yeah.
And then I think trying to achieve a particular objective, and to ensure that the person can work, but at the same time the person can be monitored, and to ensure that the person pays. But okay, so yes, so very interesting program so far. I want to really say that so far you're doing a very good job, full of confidence, and I think there are times, Madam Magistrate, when people try to leave the state. And
yes,
people try to leave the state. I think this is a very important area that we may want to give some attention here tonight, where people attempting to leave the state and to evade a particular order that has been issued by the court.
It was also under the old law, but it is more explicit. It's spelled out more in this new law. So if a party who has an order, there's their intention, or the other party finds out that they're going to leave the state, or know that they're going to leave the state, without making proper arrangements for the maintenance of the children or child that order was made for, then the interested party could go, and there are documents where you would bring that person to court so that they can make that provision. Otherwise, they can be prevented from leaving the state, or if they intend to leave the state, or they live in the state, they can be prevented from leaving the state because they have not made arrangements for their in terms of how that maintenance order is going to be paid.
Have there been instances where you have actually used that?
Under the old law, we have. Under the old law, I don't recall having done it recently, but under the old law, we have in fact done that. We have in fact done that. And what happened at that time, we would have had to drop documents. They would have had to get somebody, almost like, a shorty or somebody, who would be responsible in case they don't pay. Then this is the person that we would look for in the state to pay. So we had these arrangements that happened. And also I remember once somebody was in St. Martin or somewhere, and through the welfare division, they were brought back down because they had a number of children who were in Dominica, and they were brought back down so that they could make sure that they put the children in places where they could be taken care of, and also that they would state how those children were going to be maintained. So it has happened. And that's why I was a little concerned about the fact that when we live in the state now, we don't fill in the form, because I'm wondering how would that work with this, because usually what would flag would be, you live in the state, and the police would see that because it would be on the system, or would give the warrant to the officer, the immigration. But this can happen. So the court can issue a warrant to the commissioner of police, requesting that the person be brought before the court within 24 hours of the apprehension. And when you come, then you will not be allowed to leave the state unless we're satisfied that you have made adequate provisions for the maintenance of the child or children. Or if you attempt to leave now in contravention, then you're liable to a fine of 2,000 and imprisonment for 6 months. So it was there before, and it is there now, but it's spelled out more clearly now.
Okay, so we're approaching 10 minutes after the 9 o'clock hour. Normally what we try to do is to give out as much information as possible, so we have limited time to take calls, etc. But let us just take a few seconds, and so you can have a briefer. And when you come back, we're going to deal with another very interesting topic here tonight, an area a number of people have concerns about, and some people do not know their rights, and people who have been living together for a number of years, though not married, but they have certain responsibilities and obligations. So we're going to come back and we'll be speaking about the Maintenance Act, and we have with us tonight the most distinguished magistrate, Gloria Augustus, with us tonight. Let's listen to a little music, and we'll come back momentarily.
Teach me, teacher. Teach high and I am a teacher. Teach me, teacher. Teach high and I African teacher. I never believe. I always early. I never have sent. I always present. That's why I not sit down in a back bay. That he like to be bright, bright. So bright. Teach me, teacher. Bright, bright, bright. Teach me, teacher. So bright.
Yes, yes, a wonderful rendition here tonight. Of course, we're back and live on the number one station, DBS Radio, of course. We have with us, as I've said before, the most distinguished magistrate, Gloria Augustus, and she has been assisting us with giving us a very comprehensive explanation here tonight insofar as two very important pieces of legislation is concerned. And one we have dealt with thus far, the whole issue of the Maintenance of Children Act, and now we're going to be talking about the Maintenance Act. And let us just start firstly, Miss Augustus, to speak about the definition of the word spouse. And we have situations where people have been living together, cohabiting, as the law references, for a period of years, and then sometimes that relationship goes sour. Most times, of course, the person who is actually affected is the woman, and we have seen that manifesting itself many times. But this piece of legislation is gender neutral, and we want to establish that. So, within the spirit of the law, how do we define the word spouse?
Can I just go back to, I like a little bit of history.
Yeah. Yes, no problem.
In the old law, we had this aspect, because this Maintenance Act now deals with for spouses and also for dependents. In the old law, spouse there would be married people.
Right.
So, like for instance, people who are married and they separated, they one party will come for maintenance, or sometimes people have divorce proceedings going on. It hasn't been concluded, and in the meantime, they will come for maintenance. Sometimes separate for the child and also for themselves. And we also had this aspect where parents could take children to court, or somebody on behalf of the parent, for maintenance, but it was hardly ever used. Well, in my experience, one or two people tried it, but they never really went through with it. And because now, when the emphasis was on the maintenance of children, in the harmonized law for the OECS, they don't deal with spouse and parent and so on. But because our law had it, anyhow, we just went to maintenance of children, we would have left out that whole section of people. So there was a need to have the separate law for maintenance to deal with the dependents, would be the parents and grandparents, and also to deal with the spouses, the married people. But then in this law, under the interpretation section, the definition of spouse was expanded. So it before spouses just married people. Now it includes single people. So a single woman or a single man is included in the definition of spouse. A single woman who for a period of not less than 5 years. So if 5 years and more, you have cohabited.
Right.
If a single man, not even a married man, as if she were in-law his wife, then if they have separated, then one party, could be the man or the woman, could take the other party to court for maintenance. Also a single man too, for a period of not less than 5 years.
And when we use the word cohabit, we're talking about living together.
Living together, like man and as if they were in-law, man and woman, well, husband and wife.
Yes,
husband and wife.
And that's for a period of 5 years, at least.
Yes, at least 5 years. Because there are some people who refer to people as their wife and they're not legally married. So once it's not less than 5 years. In some countries, there's an obligation for 3 years and so on, but Dominica, I guess, chose not less than 5 years. And you know, there are some people who live together for 5, 10, 15, going all on 20 years and not married. So they're saying that if a single person, a single man, single woman living together as husband and wife for more than 5 years, and something happens, they separate, then one party can take the other party to court for maintenance. But it also includes, that spouse also includes married people, and also this law speaks to dependents, where parents, where people who have an obligation to maintain their parents, or their parents are in need of maintenance because of either physical or mental infirmity or disability, then one of the other siblings or somebody can take them, or even an institution, to court to maintain their parents. Once that person is not a minor, so an adult, it has to be an adult who has an obligation to the extent that the person is capable of doing so, because there's a whole set of guidelines as to what you look for in making that order.
But
So-
doesn't the law go further than does the parent? What about
No, it has grandparents.
Thank you very much.
But then it only takes in grandparents if they said that it only arises in the event of the failure of the grandparents' children to do so, owing to death, physical or mental infirmity or disability. So if the grandparents' children cannot do it because maybe all of them have died off, or there's physical or mental infirmity or disability, they're unable to, then somebody can be made to pay for their grandparents.
I think that aspect of the discussion here tonight is so important and maybe needs to be reiterated. And because we have seen a number of instances where you have parents and grandparents who have been left, on their own, and to fend, and they're not able to fend for themselves. And then you have children who are functional in every aspect of the word functional, and to them it's not the obligation; it's somebody else's obligation or that of the state. So I believe it's important for those issues to be actually properly ventilated in the public, so people can have a better appreciation as to what exactly are the obligations and responsibilities insofar as the law is concerned.
But even where probably somebody would say, okay, well, I'm maintaining my mother, I give her what I have when I have. If it's not reasonable, some party, maybe one of the other children or somebody can take them to court there so that it can be at a reasonable level. So some people, yes, in their head they are maintaining, but what they're giving and what they're not giving is the same thing. So there, a local authority, government agency, maybe one of the other siblings, maybe who is caring for the mother and realize, well, my brothers and sisters, they have and they should be helping me. And people have been, using it now. To me, it's used now more than before. Before, although it was known, we hardly had that happening. But this time, there are people who are coming for the maintenance of parents.
But do you have instances there, Madam Magistrate, where you have situations where people are coming before the court to sort whether they're seeking orders for the maintenance? And people who have been together for a while, will be married couples, and now you have a number of instances where people have not been married but have been living for 10, 15 years together, and then you find sometimes they're thrown out of the house and they have to fend for themselves.
Because this is new, we didn't have people come in who were not married. It was mainly married people who come in. But I have not done anyone with anybody living together and who have separated. But because in the old law it was married people.
Yeah, and that is why.
But this one now, other people, even if they're not married, but they have been living together for 5 years or more, and kaipul kwaze, things they separated, then one party can come to ask the other party to maintain them, and we have some guidelines to look at. So it's not just saying I want maintenance. We have to look at certain things. If there was a legal obligation, their capacity to contribute to their own selves, the type of support that is being given, also any contribution that was made. So, we actually have things that we can look to. And even where people are asked to maintain their parents, one of the things that we can look at too is the quality of relationship between between that dependent and the between that parent and child, right? Also, if they have a right to public funds, if they have assets, we actually have it spelled out in the law. Certain things that will guide us in terms of whether there's a need to make that order, or if there is a need to make that order, maybe at what level, or what level of contribution would be reasonable.
I think that that is absolutely absolutely important, and because I have known of cases, and I think it is so important for when you have new pieces of legislation like this one, with far-reaching implication, and you have a situation where people have been stuck in relationships for a very long period of time. They may not maybe they were not working, but they were the homemaker, and they were taking care of the children.
It's actually there
Right,
because
and
maybe what I can do is read out
Right.
all the areas. Because it says the length of time of the marriage or cohabitation. So if you're married for 10 years, 20 years, or whatever, so you look at the length of time. The longer, then the onus is probably greater. Also, the spouse contribution to the relationship and the economic consequences of relationship for the spouse. The effect of the responsibilities assumed during the marriage or cohabitation on the spouse's earning capacity. I remember, well, no, I think I will leave that. The spouse needs having regard to some accustomed standard of living during the marriage or cohabitation, whether the spouse has undertaken the care of a child of 18 years of age or over, who is unable by reason of illness, disability, or other cause to care for himself, any housekeeping, childcare, or other domestic service performed by the spouse for the family, as if the spouse were devoting time spent in performing that service in remunerative employment and were contributing the earnings to the family support. So housework, what you have been doing, how you have been keeping the house while the other person going to work. The effect of the spouse's childcare responsibilities on the spouse's earning and career development. If you were not able to go to work because you had this child who was mentally challenged, or you had to stay home for maybe how many years because of something to do with the house or with taking care of the children, or you had to postpone your career development because of that, all that will be taken into account. The terms of any order made or proposed to be made by the court in relation to the property of the parties, and also the eligibility of either spouse for a pension, allowance, or benefit under any rule, enactment, superannuation fund or scheme, and the rate of the pension, allowance, or benefit. So we have all these things that we look at. So it's not just about, okay, well, we finish. No. We go back into how long you were together, what was the contribution, what was the standard of living, what are the needs of the person, is there or are there children involved, how the fact that when you were together affect the person's earning capacity, and now that you all are separated, what happens to that person. So all these things are taken into account, and it goes either way. It could either be the man taking the woman to court or the woman taking the man to court. Some people tend to think it's one way, but it's both ways. The law actually says single man, single woman.
And it's important for us to reference that because, as I said earlier on, the law is gender neutral. And in terms of, as we're just about to wrap up the program here tonight, we have a few more minutes. And as we're talking about situations whereby you may have a situation where two people who living together in a common law relationship, well, it's not qualified under law, under the law now, if you have been living for 5 years or more, and a party applies or makes an order for maintenance. What would be the duration of that order?
Okay, under this law, you can do things for actually say that you can do it for specific times. So all this is in the guidelines. So it can be for a certain amount of time, but then if it could be for the rest of the natural life of, for instance, if it's a parent, for the rest of the natural life of that parent. Once the parent dies, that's it. Or in fact, any order, once the other party dies, that's it. So it can be for specific times, or you could have it for the rest of the natural life of that person.
Let us just try to be specific here tonight, and in terms of And so far as it pertains to
Oh yes, until they marry too. If they
All right,
get
okay.
married to somebody else,
right.
yeah.
Now let's suppose that
It's in the law.
Right. It's in
So
law,
if
right.
you cohabiting, you break up and you get in maintenance, once you are in another relationship and you get married,
Yeah.
then that's it.
Kai pro quasi.
Oh, it stops.
Yeah, stops. Yeah, okay. Okay. So we're gonna have to come back tonight some other time because and to further expand on what we have started here tonight, because we have a number of other pieces of legislation insofar as the Sweeter family bills are concerned. We have a caller here tonight. Good evening. Good night.
Yes, good night. I'm listening attentively.
How are you doing, sir?
Very well, mentally stable, and I'm listening.
Yes.
But I have a question.
Yes.
Do you have any laws for singleness and childless? Because what I've heard tonight, my brother, I love the priest. The priest will have to deal with all of that. So do you have any laws to manage singleness and being childless? The second question is, are you going to share that information, so very important information, in our schools, our secondary schools and our colleges
Yes.
and our churches,
Yes.
where there is a congregation? Are you going to do that, or just keep that information somewhere hidden and wait for the event to happen to implement the law
Yes.
or the law? I'm listening. Thank you.
Thank you very much.
I just want to mention that was it this year, last year? There were a group of, is it Commonwealth Day? There were a group of students from all the secondary schools. It was through, I forgot I think it was through the British something. And they were brought together, and I had a session with them where I give information on the new laws. But they were from different schools, and sometimes you get invitation to schools to come to speak on certain things, and then I take the opportunity to bring in some of these areas. So this is something that we do, and maybe, well, I guess we can do more of it, but it's something that is ongoing.
Yeah, I think the latter part of the quarter's intervention is very instructive there, and I think that's something that we have to explore. The fact is, notwithstanding the fact that all our laws are placed on the government website, not everybody who go to actually engage through that way, and I think that we have to ensure that we continue to bring out the information through the various publics, and which of course would include the schools, and so it's an ongoing exercise that I think we can actually qualify with time. Yeah.
But I didn't understand his question. His question about singleness, or
Well,
I
yeah,
didn't quite get it.
Yes, but yeah, very interesting guy.
Yeah,
of course,
I know that voice.
Yes, but there's merit in his intervention, especially as it refers to the second aspect of his contribution.
Yeah, and even in terms of, social studies.
Good evening, you're live.
Yes, the singleness question.
Yes,
I
yes.
asked. Okay, it's an option.
An offer.
Okay, I be single and childless, or go and tie yourself up with this kind of system. Yeah, simple as that.
Okay.
And I love priests who have moved on the Bronca. Yes, moved away from that. Just one example. Put the brakes on them. That is one area, and I hope you understand what I'm saying.
Yes. Okay.
The question is there anything for singleness and childless? Because I find it's a beautiful life. All this rigmarole, this relationship outside, my friend, being single and childless, I think it's an opportunity, it's an option.
Okay.
So do you have anything against that? I'm listening, thank you.
Yeah. Well, the thing is,
We want population, so we're promoting singleness and childless.
I think there's a discussion to be had on that in terms of you exercise your option, whether you want to be single or whether you want to embark on having a family. and have children. That's another option you may want to explore. And okay, so we, Miss Augustus, it has been a wonderful night so far, and I'm not sure if you want to touch on something finally on this matter here tonight, insofar as it relates to the Maintenance Act, as we just close up here tonight.
No, I'd just like to encourage parents to recognize that maintenance is not just about giving support for food, but it has to be a reasonable amount, and maintenance based on the welfare and development of the child. Maintenance really should be able to give support for entertainment, health, education, accommodation. It's really the full package that will allow that child to have a reasonable standard of living. So it's not just about, I just give the clothes or I send the clothes or, no. It's much more than that. And if we go to supermarket and the market, we realize that things are getting more expensive. And also, I think too that we need to look at how we, certain things that we buy in Dominica and how we can make the money stretch too.
Okay, let's, good evening, good evening.
Yes, let me just, I have another question.
Mm.
There's a saying that goes, if a man allows a woman into his life, he has to provide for her, protect her, and secure her.
Mm-hmm.
Is that legal? Is there a law on the books that says that has to happen, or is just a saying by the side of the road? Thank you so much. I'm listening.
Bible.
But I think when we made reference to the Maintenance Act, it places an obligation on both parties. In the event if one is dependent, and then so
nobody has protect. He has a whole set of things.
Yes, right.
I don't know if that's all that.
So it's a far-reaching piece of legislation, very progressive too, and I believe if we continue to just to close up here tonight, Miss Augustus.
Okay. So the court is there for both parties. Mm. So sometimes some people say, well, I had the child before and I didn't take her to court. It's your right. If you think that you are the person who has custody of the child and you would like to get maintenance, you're not getting reasonable and consistent maintenance, then you can come to court, because this is where it should happen. And some people are adverse to coming to court. From the time they come to court, then it almost like changes everything. Mm. This is the place where it has to happen. And if you notice, when you come to court, other people from the public are not there. These matters are not matters done with people sitting there and listening to a business. And according to, if you are not comfortable with somebody inside there, I could even have them to go outside. So it's just that we need to meet where there's a law for that in every country, everywhere. And you would not be the first, you would not be the last, but we're hoping that at least you would try to maintain, whoever it is, man or woman, maintain so that you don't have to be there. But if you are there, then let us do it in a respectful way, and let us do it in the interest of the child, knowing that this child is a product of the...
Okay, we're trying to... we want to wind up. Good evening.
Good evening, fast and quick. Now, I know what all this law, I love everything going to say what I want to hear a law now. You see when somebody married, a man or a woman married, and they have children outside, man like woman when they married and they have children outside. When you see something happen, when you see the resources, the man pass away, the wife pass away, them children outside supposed to be part of the resources. I would love one to pass a law, because that is a serious, serious problem in this Western Hemisphere. Up and running, fireman running, bless up, I'm listening.
Just for information, we have the Status of Children Act that actually defined.
There's no discrimination under the Status of Children Act. There's no outside child.
Okay, so
all children are children, and that has been erased.
Okay,
so under the Status of Children, no outside. All children are to be treated equally.
For matter of fact, one of the progressive things that was done was actually actually repealed this law that referred to a
To
child as a bastard.
legitimate and
A
illegitimate.
bastard.
Yeah.
That was actually in our laws.
Yeah.
I mean, it's
So
very-
all that has been erased. Nothing about legitimate, illegitimate, bastard.
So you know,
Yeah.
okay, yes. Sometimes we try to just edify the public, but we can take one or two calls towards the end, and that's not a problem. And we're actually absolutely going to allow you to close right now.
Oh, I forgot what I was saying.
You're talking about the courts were there for and what the court have been doing.
No, I just like to encourage parents to, in the best interest of their children, to really collaborate, compromise, be civil to each other, because when the parents have issues, that affects the children. And I'm saying that because I deal with children otherwise in terms of juvenile court, and I deal with custody matters and domestic violence, and a lot of the issues between the adults impact the children. There's somebody in between, that child in between, and the child usually, well, most time the child loves both parents, and whenever they have these disagreements between them, or it will affect the child in one way. Sometimes some children are good at suppressing it, but it shows up at some point, or it affects their way of life at some point. So for me, it's about the children, and I would urge parents to try. And even with the ladies, I find a lot of ladies like to feel, well, okay, like in my court, you don't say my child. I don't want to hear that word. It's our child, because once you think my, that is a problem already. It's our child, unless it's artificial insemination, maybe, but it's our child. And also, what I would want to say is that the better relationship that the parents have is in the interests of the child. Once they have a bad relationship, and you find a lot of times the mothers, I usually see that more for the mothers. Some fathers are willing to be fathers or want to have that relationship with the child, and the mother is really not helping that.
Well, I believe, Mr. Augustus, that issue, I think, can be further qualified in terms of parenting and when we look at the Status of Children Act, I believe that would further amplify that situation.
Yes, because the Status of Children Act, it supports co-parenting.
Okay. Right.
It supports everybody has the same, like before. If once you're not married, then the mother had the mother would be the one with the most rights in terms of saying what has to be done for the child. Under the Status of Children Act, that too has changed.
Okay.
Fathers have more rights
Well, when you say more right, that's relative to what
than they had before.
Right. Thank you very much.
Legally.
Legally right.
Yeah.
Okay. What an excellent program it was. And I want to say thank you to you, Madam Magistrate, for being here tonight. And you spent the whole day sitting on the bench. And you're here tonight still tired in your working.
Yeah, I had meeting and meeting and meeting.
Yes. And knowing someone like you who has the passion insofar as it relates to family matters and the laws, of course, you have been a patriot, and rightly so. You have been actually given the national award for your contribution so far. And I think anybody who has been given the opportunity to have received an award on the national level, of course, is a great Dominican. And you being here tonight is a further manifestation of the commitment to serve your country. And I want to wish you well, and thank you very much for being here tonight. And thank you very much to our wonderful listeners, those of you who sent your messages via the Facebook page, and of course, to the callers who called it tonight. What we'll do at our next program, we maybe allow more people to call. But I think the next time we meet, we'll be maybe looking at some other aspects of the suite of family laws, and nobody is better qualified than Ms. Augustus to further explain to us some of the issues that we need to know. So have a nice night to Ms. Augustus and our wonderful listeners, those of you in Dominica and overseas. Thank you very much.
You're welcome.
Okay.
I and I